Samantha Pasha and Will Robinson are still like, oh, backs up whenever you're talking about the U.S. attorney. It's like, whatever, what difference is there?
Yeah.
Get the case over with and go elsewhere. Mm-hmm. So one guy pled, they call it a Rule 20 out in Virginia, even though it was for a case here, because you can do that. You can plead in a different federal district if you plead. So he pled out there and he's over here, and now he's being prosecuted over here. The one kid that pled in state court. One kid that pled over here hasn't been able to go over there yet. This is like a year and a half now. Yoder is the only guy, and thank God they took him over there because he got the shit beat out of him when he got the lawsuit. So he's happier than hell to just go into federal custody. And this Thompson guy is over there, but he hadn't been to the state yet. Mm-hmm. So there's like 4 different people that are all in different stages of getting both done, and neither one is willing to give it up. You know, we've got a sentence in state of California, so what about just for the federal? No, we're not doing that. That's not the way it works. So we, I think I told you, maybe I told you, that we got Claudia passed the bar.
Yeah.
Did I tell you that?
Well, we found out the other day because we had Strucker who passed.
So it's 44.4% is our pass rate on the way they evaluated.
When do you guys have to be at 50% by?
You don't even have to ever be at 50%. You have to have 40% to be state.
Oh, to be state accredited?
Yeah. So we can now apply. So then I'm sure it's got to be a ridiculous year-long process. Although we just got a 5-year evaluation, so.
Well, when do they stop allowing the unaccredited ones to exist?
Well, they just are talking about that.
Oh, they haven't.
What they're saying, they're not saying that. What they're saying is we want everyone to be state accredited as soon as possible within 10 years. And now they're going to accredit online schools, et cetera, because they used to make this distinction that you could never be accredited. So, and now, of course, all the people that knew about the legal system that worked at the state bar are gone. That's all people that came from the Department of Consumer Affairs. They have no knowledge about lawyers, or really they meet with the Committee of Bar Examiners, and it's all about discipline and all that.
You think that's why the bar pass rate went up?
Yeah, it went down.
Well, I thought Drucker said it went up.
No, it was a little.
Oh, yeah.
The overall rate was 40% this time, 27% back February. 55% for first-time takers.
Oh.
They were 50 or 55. But 40% overall, I mean, it's still really bad.
Yeah.
And I don't know if they're attributing it to students are stupid, more stupid than before. You'll excuse the expression, the grammatical expression, or the bar is harder. I vote for the bar is harder.
Yeah, I mean, I do think
my
brain is not trained for mass memorization like that. You know what I mean?
Yeah.
I've never, it's not how.
I always thought if you could understand it, then you wouldn't have to memorize it.
Maybe.
You know what I mean?
Right.
So that's what I always try to do, is figure out why and wherefore and all that. Look at this, the protection of the public is the highest priority of the State Bar of California. So we pay $800 to have them make sure that we don't violate the public's interests.
And you pay for your card.
What's that?
And
You pay for the card.
You pay for your card.
Yeah.
Right? Because unlike
everybody has the paper
fancy
one.
pants over here,
You got the paper one?
I got a paper one that's
I think they have to,
because they won't even send me a card. I think
you have to give them $25.
and you got to pay for a nice plastic.
Which you used to get. I mean, you would think because it's $800 because I have those criminal law specials.
Oh.
You would think for that, it's otherwise it's only $500. You would think if you paid that kind of money,
500?
you would get a card.
A year?
You get nothing. A year? Oh yeah. Oh yeah. I'll tell you what else. You would choose as you get the bill, you pay it usually November, December. Thank you, sir, very much.
That's for the boys.
Oh, thank you very much. This is for passing out to the boys.
Yes.
This is your syllabus for community property. Take one, pass it down. Yeah, every year, and so you pay your thing in December, you get the card in March. And so for about the end of January, the beginning of February, for a month, the deputies say, well, why don't you in 2019? I haven't got it yet. Oh, sure. Oh, they get all concerned that you might not be the right person to come in and see somebody in jail. Like you would want to go do that.
Maybe you're trying to smuggle drugs in.
Oh, yeah. For me now, I can't even hardly get into court. Like, you got your card? I'm like, I don't have a card yet. And I started to get one. They said, well, it's from January to December. I said, same price, but you're not gonna get your full benefit.
Yeah.
I'll wait till January. I'm gonna pay my $25 to get in.
It's.
For now, I'll take my belt off for you.
I know.
I'll act like I'm not a
And
lawyer.
the same guy that you see for 30 times in a row.
Yeah.
So they've seen your car 30 times. And for $15, you can get a little badge that gets you in the lawyer's line. But you have to pay $15. Your bar card doesn't get you in there. It has to be the badge.
Yeah.
I have my badge, as a matter of fact. I keep it in my pocket. So I put it on, and it has your picture, and it says Riverside. And then you can go into the lawyer's line. Otherwise, you have to go into the juror's line, even if you're a lawyer, which is just ridiculous.
Yeah.
Palm Springs is much more lenient.
They are, yeah.
I go to Palm Springs and I beep and I'm like, it's my ballot. All right, go.
Yeah. And now, everything for the most part is moved to Palm Springs.
Yeah.
So, it may not even be an issue for me, but a couple times I've had to go to Indio. They've only seen me for 20 years.
Yeah. Who are you?
Who are you?
Okay.
Okay.
Yeah, so Evans and Nikki Reed are going to Palm Springs. And Chapman's staying there.
I thought Hop was going.
Pappas, he's taking
They're gonna
over
have four- they're gonna have
for, what's his name?
It's good lighting.
Lanning.
It's gonna be Hop, Evans, Mickey Reed,
Whoa.
and Chapman. They're gonna have a PS4 for Mickey, which is gonna be small claims and also whatever else.
Where are they putting it?
Trainers.
In the back, on
I
the back
think
right?
so. Or maybe downstairs. I mean, there's a whole bunch of room downstairs.
Is there? I didn't know there was a downstairs.
Oh,
yeah.
Okay.
Yeah.
There's a huge sound.
Oh.
If you go,
Well, I know there's stairs there, I just.
yeah, that's what the
I
stairs
just had no reason to ever go down there. Like,
I'm guessing it's gonna be downstairs because I can't. I don't think
are. There's no fourth
There's
floor
only
up
three.
top.
there's only three.
So, all that civil's going over there. Juvenile's coming here. And it's gonna be 3 days a week juvenile,
In the Lars.
yeah. It's gonna be Elizabeth Tucker doing 3 days of delinquency and 2 days of traffic and stuff. And then Suzanne Cho doing dependency. That's gonna be a 1A and 1B. That's why Evans is going over there with the probate. So, cause that's what's there now. And Lanning is gonna become a criminal judge, which will be very interesting since I don't think he's ever seen a criminal yet. And then Holland Horse is over there now. I'm in trial with him right now. And then Benjamini and Olsen will be there. Villalobos. And eventually, they say that the juvenile will get knocked down. When they build a new building, it's juvenile and family law. So they'll move the family law over there as well. And they'll have more criminal courts.
Where's that being done?
Right where juvenile is now.
Oh, okay.
That's why they're moving over here, because they're knocking down the building.
Oh, okay.
And I don't know if they're knocking down juvenile hall, but I think they're knocking down the juvenile court building to begin with.
Mhm.
And supposedly, of all the places in the world, in California, we have funding for this finally. Yeah, but that's, what's that, 2 years at least? Jail's gonna be done pretty soon, I guess. It's a vast difference from what it was. Do you remember? I mean, you remember.
I haven't driven by in a while. I don't remember. I've never seen one.
There was an old funky building, big tall building, where the DA was, PD and all that stuff, county council. And then there were 4 courtrooms along the edge there. And that was the entire place for a long time. And I don't know what year the Larson Justice Center was built, but
It had to be like 95.
yeah, something in the late 90s, I think. And so then the other 4 courtrooms are still used, although they were pretty cheesy. There was one real big one, 1A, it was real big,
Mhm.
and then everything else is pretty cheesy.
They were set up weird too. I remember like one C and D, like your
Yeah.
table's this way, the judge is over in the corner at an angle.
Yeah.
You
remember that?
know?
And he walked out of the back of it to go in his chamber.
Yeah. It's
And,
odd.
It was weird. But now those are all gone. And apparently the construction must be bringing out all the cockroaches because they have people telling me that they wake up and there are cockroaches crawling over their face in the middle of the jail. It's just bad. And eventually, it's not gonna be much trouble getting people from the jail because they won't be having to put them in Southwest.
Yeah.
Very busy.
It's gonna be full, right? As soon as it opens.
Well, and it is gonna be full because they can't open the whole thing, so they're gonna open it up level by level. That's what Stan Sniff said, although apparently he has nothing.
He's out now, so.
So maybe it'll be different. It's a mess. It'll be good though, to be able to have more people that are not in Southwest or Banning or wherever. Because it is, the other day, in order to go to Vegas, I went to Banning on Sunday morning, not Banning, Southwest, and saw 3 people. Then I drove to Vegas, And then we did our appearance on Monday, and because it was late in the afternoon, we stayed. On Tuesday, I drove back and hit Banning on the way back to see 2 other people. So I actually did a lot of new client or present client interviewing. And of course, Yoder's case takes set at 4 in the afternoon. It took 15 minutes. So, but you had to be there. Be there. Don't be late. And whatever, you know. And she,
No court call
other
for
than
that?
that's how federal court goes. She was very nice, considering some lawyers or other judges are nasty.
Well, you know, I learned, I'm still learning so much. I had this motion on a civil case, and there's multiple parties. So we've got like 6 parties going. We got cross defendants and cross claims all over the place. And there's this motion filed, and there's responses across the board. Judge gave a tentative yesterday, written, which is perfect, you know, because it's nice.
Sitting down in Palm Springs.
He's sitting in Riverside, and apparently you have to lodge notice if you want to make an oral argument.
Exactly.
By 4:30.
I was not aware of this rule.
It says it right on the tentative.
It does. It does. But I'm like, I'm not really a party. I mean, I'm a party to the case. I'm not a party to this particular motion. I don't really have a say.
Oh, you don't have to. You don't have to. You know.
And somebody tried to argue, and the other
They
side,
didn't give notice.
the other side said, Your Honor, just so you know, they didn't give notice, and that judge shut them down.
Goodbye.
Yeah, would not even.
Who was it? Vineyard?
Simpson, something like.
It's just interesting to see how the little quirks of court.
And I would think, all my years here, I can just imagine standing up in front of any judge here in the desert. Your Honor, they haven't given notice to oral argument, and our judge is like,
Come on, man.
I'll let them.
No, they shut him right down in civil.
Yeah. Shut them down real quick. Like, okay. So this little notice thing I better take serious if I want.
If you want to talk. Yeah.
So
let me just change the subject for a second. I have talked to Jeff Economides and Stephen Sorensen. They're all ready to come over. They're part of the coaching for the Palm Desert. Yeah.
I would never thought that Jeff would get
Isn't
involved.
that funny? I didn't know it until he told me in the elevator.
It seems like a.
So I would like
random
you
person.
guys mind being here about 5:30 instead of 6 next week? Because I'd like you to talk to your various witnesses, and then we should probably get choreographed. And I would say if we started even by 6:15 or even 6:30, really this trial, will take an hour and 15 minutes or something, an hour and a half. I don't know.
Yeah.
Believe me, it goes faster than you expect when you're actually standing up doing it.
Yeah.
Would you do me a favor too and give me a hard copy of your motions? You already gave me, I got the email.
Okay.
And then I'll just act like I'm a judge and be rude and condescending. And then once we do your pretrial motion, it's right into opening statements and, put on your case and cross-examine and put on your defense and cross-examine and give your closing arguments. It goes by pretty fast.
When we were going to change, or do you want to do the opening, right?
Oh, it's fine with the one we had set up.
Oh,
Come on, yeah.
Okay, okay, never mind.
Okay. And I really think just going through this drill will really help you, because it's one thing you can study this all day long. And I think if you watch in court, you probably get a lot of feel for this. But you've got to get the process down before you start really getting your thinking and argument done, because everybody's so worried about the process in the beginning of their career that they're not quite as clear on their arguments. And then after a while, the process becomes routine, but it has to start somewhere. That's why I would say, even if you're going to do civil, go volunteer to do a bunch of misdemeanor trials just to get some trials. And you don't have to, but it takes 2 or 3 days. You go from the beginning to the end of the trial. It's a good way to get experience. I mean, Pete's got vast experience, so he walks into a civil firm where a busy lawyer might have 1 trial a year, 2 trials, I guess, and he's got 200 trials or whatever it is. So, I mean, he's lucky, other than not knowing about 430 and the tentative and all that. Which, I mean, you learn something new every day.
well, I guess I was surprised how they enforced it.
Yeah.
I'm not used to that.
But because they don't put it on calendar.
I'm
And
used
if it's
to
not on
this.
calendar, then they don't want to listen to
You
it.
don't have time.
Yeah. I'm just used to everything being relaxed in criminal. Right? If somebody didn't follow something, okay, you know, all right, well, we'll hear you. And they might not change their ruling or anything, but they'll at least let you be heard. You know.
No. On a totally separate subject, I should tell you, this famous humorist by the name of Jeannie Robertson's in from North Carolina, and she's in the McCallum tomorrow night, and she gets a couple of comp tickets. I know it's short notice, but if any of you wanted to go to the McCallum to see her, I could get you a comp ticket. I'm going to go meet with her for dinner tonight, a little late dinner, and I've known her from the Speakers Association maybe 30 years. And she is as funny as she can be, and she doesn't say one cuss word. There's no, sexual innuendo. I don't know how somebody is funny and not do that stuff, but she's really good at it. Pete and
Very good. My wife followed her on YouTube and knew about her before we ever knew that they had a relationship and they knew each other. And John set up an opportunity for them to meet. No, she was just what's her name?
Jeannie Robertson is her name. She was a Miss America contestant, let's say in the 60s. She's probably 6'5", and then she wears high heels on top of it. So she's got tall jokes, and then her husband is a real interesting guy, and so she calls him Left Brain, and she always makes jokes about him, and she makes jokes about the South, and she makes jokes about traveling. But it's amazing to me, she can go for an hour and a half, and you're just fascinated as she's talking. And she's saying really funny stuff. And at the end, he goes, she didn't say fuck, shit, bullshit, or whatever one time. It's just unbelievable that she can do it. Yeah. She's got to be pushing 82 right now. Yeah. Maybe 75 or 78.
Yes.
And
she's wonderfully talented, though.
She is. And you'll see things on YouTube. She just sends stuff out when she get on her email list. And it's always something new and funny and weird and, I don't know. It's she always has funny names too, like "Don't bungee jump naked." Well, that's good advice in any realm. But and then she tells a big story about bungee jumping in New Zealand and all this shit. And every one of them has one of these titles and then a story that goes behind it, and it has a punchline at the end. It's just unbelievable. So if anybody wanted to go on Friday night, I realize this is already Thursday. I forgot that she was coming, and she called me on Tuesday and said we had a couple of tickets. So I see no one jumping out of their chair. But if you want to, I'm going to go tell her.
I'd recommend it.
The names of people.
It's a funny show.
No, I need to work on.
Yeah, we got stuff to work on. I get it, and that's totally off the subject. But she's a very interesting and very talented person. And Pete can't go because he's got something else going on. Because Karina, I know, is just fascinated with her. She just loves it.
We don't have it up in our new place, but in our bigger place here, we used to have a picture of Karina and Jeannie up like on our mantle in our living room. And people would come in and they're like, "Oh, is that Pete's grandma?" she's a white lady. And you don't know who this is? Oh, let me show you. And
Start pulling up YouTubes.
I'm gonna look her up tonight.
Absolutely.
She is, and all of her little skits have millions of hits.
Yeah. It's unbelievable. She was a professional speaker, would go to like a convention and do a speech at lunchtime or something. And she stumbled into YouTube, and then YouTube got so popular, this other friend of mine, Al McCree, books her now at these gigantic venues, and she comes walking out like doing a one-person show. And that's all she does now. I mean, I guess if somebody hired her for a convention, she makes a huge amount of money. And so she goes from city to city to city, like all of us used to do back in the day. I don't even have any interest in that anymore. And then she collects money every time she goes and goes back to North Carolina and lives. And it's just a real weird life, but it's an interesting thing. So I'm going to go have dinner with her tonight. She comes into town, she doesn't know anybody. So she calls me and then we go out to dinner and, it's like a little visit. And so she got to know Pete and Karina, and she was very, very entertaining with them at dinner time, and then they do a little thing, shows will have this, where they have a little green room, and before the show they'll meet with the VIPs. Well, we were the VIPs, and of course we weren't terribly important to anybody, but then she'll bullshit with you. And I think the last time she was here, she talked about going on that old people show, what's his name?
It was Steve Harvey.
And it was a bust.
Yeah, he had a show where like talented older people would do things.
Yeah.
Like the young kids show
Yeah.
that he has,
And
it didn't quite work out.
and like Steve Harvey's people had reached out to her and solicited her to send in a tape, and she's like, okay, you guys, I just need you to be quiet here real quick. I'm going to do this tape, And was it Justin?
Somebody recorded
her?
Justin, yeah, it was Justin.
And just okay, and just went.
Yeah.
And just nailed it. Just ad-libbed it. Just nailed it. And I'm like,
Yeah.
that was really good.
Yeah, she's amazing. She is an interesting person. It's so sad now that I'm slightly older. It's like dinner after 5 o'clock or 6 o'clock. I won't be home by 9. But
I think that way now.
I'm telling you, by Thursday too, you do feel that way. I used to look forward to Friday as to go out and have fun, and now I look forward to Friday as just flop. Get done with court and do a couple of things, and 3 or 4 in the afternoon, sit in the chair and probably not get up for a couple hours. Bathroom, that's about it.
I used to look at Friday, like, okay, I can stay up late, I can sleep in. Finally, the next day, no, not anymore. When I'm in school.
Oh, this Saturday, if you're, these are some of the best lawyers around.
It's in there at work.
But I mean,
Diane and Eric were, they walked.
Bill Shapiro, phenomenal. I mean, probably the best PI lawyer in Southern California. Evans is going to be on it. I forget who else, but you guys should come in. Of course, planning we didn't quite do as well as we should have. It's the Tamale Festival.
Oh, is it an MCLE on Saturday?
Yeah, you don't have to come, but I'm telling you, if you really care about civil litigation, Rock Soda, Joe Gibbs. I mean, there's just a whole vast collection of people you could learn a lot from. Oh, Sean Murphy's coming. They're talking.
I'm coming. I'm not speaking. I'm trying to learn this stuff.
Talking about sex storage, where you give somebody a sexually transmitted disease, and he's made a big bunch of money doing
The Aussie guy, the Aussie hair products guy, that's his case, right? Like the syphilis.
Yeah.
So he won like $4 million in that case.
Yeah, no, I mean,
Yeah.
talk about a specialty.
Yeah.
I don't know, but those cases freak me out.
Well, yeah. They're a little
Like, you never know what's going to happen, then all of a sudden, if it does happen, oh, where's my $4 million, please?
Well, sometimes the $4 million is 10 years away. But it's a very interesting area, and he's a very interesting lawyer. I mean, these are top flight lawyers, and I don't know how many, we're going to have our whatever students show up, and plus some lawyers, probably be 20 or 30 people. But I mean, these are really heavyweight kind of guys. Shapiro came over here before, and he was like just raving about our building, and I said, well, come back. And he just got the Lifetime Achievement Award from Western State 3 months ago. We went down there for this thing because he is really a heavyweight. And he's also a country music singer, and he has a big sort of a tilt-up building where he has a mock courtroom and an office and a bunch of stuff, and a car collection. Has a car, every band that he's ever had since law school and whatever. He's just a real interesting guy in many respects. And so it'd be a good guy for you guys to see. So we have to be down here real early to not, last year, I don't know if I told you, the church next door
park here
was charging money to park in our parking lot. And I drove in and they said $10. And I said, what? They said $10, for parking. And I go, buddy, this is my parking lot. And so apparently they parked a bunch of cars in here before we got here. So we got to put the barriers up, and we're going to put a chain up, and then I'm going to have to come and roll it in, let our students in, and our speakers in.
That's so bad.
Isn't that weird? We made a deal with
$10.
I made a deal with the city that we can leave these parking lots open on Sunday that people can park. I don't care if we're not here.
Yeah.
The place is locked down. But they sort of took it one step extra. Decided they were going to charge money to park in our parking lot, which I thought, well, okay. I mean, it's for religious purposes, but it's not good that they didn't ask us about it. And so we got to prevent.
Judge not, lest ye be judged.
Yes. So it'll be, but it's going to be a really good program. And the other thing that is going to be really good, if you guys are around, the 26th and 27th. This is like the end of the year when lawyers got to get their hours in, or they get in trouble, so they come for a day and a half and get all kinds of hours in. And the last one is going to be, we're going to do a half day of negotiation, and we're going to do a little presentation skills thing. Then these guys from this group called the Rainmaker Institute that basically tells you how to manage your business so you can get more business in and do a better job and have better client relations. We're going to come, and they're really good.
Is that on Saturday else?
Huh?
Is that on Saturday else?
Saturday and half a Sunday. And then
What month? What month? Because the 26th. Oh, January.
Oh,
Okay.
January.
I was gonna say 'cause December, that's a weekday, so.
The last 2 weekends in January are disaster time for lawyers who haven't gone anywhere for 3 years. So they come out of the woodwork. They could care less what subject it is, just give me the hours. And so if you give them any value on top of it, it's just extra. So every year for years, we've been doing this since 1991 when they started continuing education. And the week before, it's all about, there's all these new ethical requirements. The professional responsibility stuff is just ridiculous. But you guys, you'll have that class next semester.
No, we already took professional responsibility.
No, that's right, you already passed. What am I thinking? Although what you passed on has nothing to do with your requirements right now.
No, it does, because.
It was only the federal ones. We didn't even have to learn the California ones yet.
Oh, yeah, so it's very much like the federal ones.
Yeah.
We learned the ABA rules.
Yeah, we learned that, yeah.
So
And
it's
it's
not,
almost exactly.
yeah, it's
like that.
almost, they have actually on the website, the old California rule, the new California rule, and then the new California rules are very much like the federal rules. It's not that bad.
Was it federal rules or was it?
Well, it's ABA, but ABA is basically federal.
Yeah. Unfortunately, there's a lot of stuff like how you rent your retainer agreements and where you put your money when you get it and when you can have your money. And the mess, especially for the criminal lawyers. I mean, for everybody else, sort of that's already been done, where you put money in your trust account and you take it out as you earn it. Criminal lawyers have never done that. And so now it's a disaster and you have to tell people.
Because usually it's a flat
you
fee,
say-
right?
5% for your arraignment and 13% for your preliminary.
No, you can pay yourself, you can take it out daily if you want. You have to just tell them, like, I think this case is probably gonna, let's say it's a murder case. I think this thing's gonna cost 50 grand.
Yeah.
I need to fill this thing up with 25, and then by the time I'm done with the arraignment, I want the other 25, and then I'm gonna, every month I'm gonna bill out.
You can do that, but that's if you're used to just putting it in your general operating account, because that's how you do it.
Right.
Putting it in a trust account and then going through the process of taking it out is a little cumbersome. But and there's ways around that. There's safe harbor rules, they call it, and you can also give them alternative of an hourly rate rather than a flat fee rate. And there's a bunch of stuff. Just a lot of work. That
You can still get it up front, you just have to not.
You have to bill off of
but
it.
you can't put it in your operating account.
Right, no.
Although you can say, the bar requires that we do this, however, if you wish us to take your case, you can put in a whole bunch of stuff with disclaimers and then take it and do whatever you want with it. But then you've got to do all that, and then you've got to give your client the choice and a bunch of other stuff like that. So it's a mess. But I mean, okay, it's not gonna make a big deal.
Initial here.
So what is it that you're, if you are confused about anything in your trial yet?
Yeah.
Yeah, well, let's go over it.
I got to the, how knowledge are our expert witnesses gonna be?
They're gonna know what's in
What's in
the paperwork.
Yeah, what's in the paperwork.
Yeah, so.
That's all they're gonna know.
Yeah, no, so.
They tend, by the way, the kids tend to sometimes embellish at a few things, but you gotta be very careful.
Okay, because I was typing out my line of questioning, but for direct, and I was just like, is he gonna be able to explain all this stuff, all the technicalities?
If it's in the paperwork, they should know it.
Okay,
And if it's not in the paperwork, you're not supposed to go off script.
yeah.
So you're gonna have to make sure that your questions are relevant to what's in the paperwork.
Yeah.
Does that help you?
Kind of, so I was like, yeah, because if I get an expert that's like, I don't know, or something, it's like.
Well, if I don't know is part of their script,
That's
then-
what I was looking
and so that is supposedly, although there's fudging that goes on all the time in the mock trial stuff,
Okay,
but you try and keep it down Main Street.
all right, just kind of, all right.
Yeah. Now, you guys were just talking about opening statements. I just want to make sure, I know how we've divided it and he's doing everything.
Okay.
We want to be able to see you guys do a little of everything.
Mhm.
We want to see you direct and you direct. We want to see you cross and you cross. We want to see you argue and you argue. Now, how you break that up, right? One of you does oral, one of you does opening, one of you does that's on you guys, but we want to see each of
Yeah,
you
that's
do.
When we divided stuff, we didn't consider the motion.
Oh, I think you're okay on that. Is one of you doing are you doing the motion?
I'm the one that wrote it.
So you should, that's fine.
But
You
I'm
don't need to have two
already
people
doing
do
the
the motion.
opening and the closing.
But you're doing the rebuttal, right?
The reply.
The rebuttal.
That's fine.
Is that fine? Is that enough?
Yeah.
You know, if you have one of you do the opening, one of you do the closing, we're gonna see you stand up and talk to the jury. That's fine.
But that's not what.
Well, if he's doing the rebuttal, it's still part of the closing, so.
No, rebuttal is not part of the closing. Oh, you mean the rebuttal of the argument?
Yeah.
I thought you meant when you were doing.
No, the rebuttal of the closing argument.
You can do that, as long as, but the big advice is rebuttal needs to be a rebuttal. not the same argument that was made in the opening of the closing argument.
Don't listen to him.
What the other guy said.
Don't listen to him.
Objectionable things.
Just repeat your closing again.
Please don't. Rebuttal is supposed to say, here's what they said, and here's why they're wrong, or why you should see it another way, or whatever. But okay, yeah, that makes sense. You could do that, I suppose.
I think it was just because I think it was doing the opening, but then I also was doing another opening. So I don't know if we had to do
I
twice
haven't
the
written
work.
the open yet. I kind of like am down to not do it. I don't want to.
I'll show it to you, and you can probably take from it.
Okay, maybe yeah. I mean, I know where I'm going with this stuff. I
It was hard, man. You had to pretend this is like the worst criminal in the world to get some motivation, right?
Worst criminal in the world.
Well, no, it's about setting an example. This is the one caught.
Exactly. Go somewhere.
All right, so let's, what I thought we would do, tonight, everybody's trial binders, I assume are complete. If you got questions, we're not grading them tonight, but if you're missing anything, if you got questions, talk about it tonight.
The only thing I still have to do is the reply to the motion.
Right, and remember, when we're looking at your witness sections, we want to see that you put some thought into it, not just take the page of their statement and that's in your binder. Right? We want to see either a bullet point, this witness is going to talk about these issues, these exhibits are going to go through this witness.
Where I was doing, I was writing out the questions to see if I could get the story.
There's his hard copy.
So I was just kind of following that.
The motion
In response to your motion.
Yeah,
That's where I got
I will-
started with the.
I will get you a hard copy. I
And
just
just work out about
to
the
explain
office.
it,
We'll sit on my desk and when I get
Is
in,
the
have a break or whatever.
witness to be able to do it, explain the technicalities.
Well, you should be.
Should be, right?
Right.
So,
Someone
did you
treated
write down
like.
position before he got the 905?
No,
No.
I wrote the 995 first.
So did you.
I don't know, how do you address, like, do you address like this? We don't do things like this, but
What are you looking
I
at?
noticed some of the like the prosecution motions, defense motions do a, like, to the honorable, blah, 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 the court clerk and, all that stuff.
Mhm.
Do you guys do that stuff? I don't remember.
Our form motions in the DA's office did. I can tell you the motions that we have, that I've done in civil,
Yeah.
don't.
Yeah,
Okay, so
same with
it
us.
seems to be more of a format. I'm sure the DA's office probably still does that.
See, things I don't recall ever reading like replies, because like on the defense side, when I was over there, I wrote a motion for the attorney, gave it to them, and went on to the motion.
Yeah.
Like they took care of the opposition and their argument, and
Normally what happens is once you write the motion and it's filed, when they get the opposition, they just have the two together and they argue it in court.
Okay.
They don't come back and do a big
Yeah.
production about it. So, and the opposition normally comes, if it's a 995, the opposition comes, supposed to come 5 days after the original,
Mhm.
so there's some rules about 995s. You have to bring it within 60 days of the information arraignment. And if you do, then if you don't like the ruling, you can take a writ. But if you bring it beyond 60 days, then you can't take a writ. So if you're really got a very heavy case,
60 days to do it.
and so then after you file it, you set it for 10 court days down the road, you're supposed to get a response within 5 court days. That's the general rule. So that both the motion and the opposition are in the court's hands, although it's all on the video screen now, although sometimes they print them out. And so then everybody's had enough notice to be able to come in and argue the case.
So am I supposed to do a reply or no? Because
No,
I was going to do one only because I thought it was going to affect my grade. But if one isn't actually supposed to be done, like in an actual
You
case.
don't do replies to 995s most of the time. You do
Okay.
995, you do the opposition, that's pretty much it.
And then you argue.
Yeah.
Okay.
If there's, and this isn't a 995 rule, but let's say I filed a motion and got a reply. If I wanted to address issues in that reply, like the cases that were cited or what, I would do that orally.
Orally.
I wouldn't write a reply brief.
Only if it was like a big damn case.
Okay.
Which reminds me, I don't know if you heard that we got a stay from the appellate court on the Felix case. We did this whole pre-guilt phase court trial on the Atkins, intellectual
Oh, yeah.
disability. And we filed 1,600 pages of exhibits and then a big brief. You can only file so many words, writ brief. And the appellate court said, stop, don't do a trial, we're gonna look at this, which is interesting.
Nice.
I don't know that means anything, because they'll probably get the responses due December 10th, unless they ask for an extension, they probably will. And then I've had things denied without anything, just denied goodbye. I've also had it where they say, we're gonna look at it, or we want oral argument, or whatever. And then if we are denied, we're gonna go to the Supreme Court. So I thought that trial was gonna start in December or January, and now I would say June. Which is fine with me because I got plenty of stuff to do. But it's very rare that you get a writ and a stay granted for a writ to be evaluated. But let's face it, in a death penalty case, if there was ever a case where you would give a stay and consider something like this, and it turns out we caught him on a couple of things that I think we got some.
So what was the order again? You have to apply for your writ within 60 days, and then you set a court hearing.
No,
days
not apply
later.
for your writ. You have to file your 995 within 60 days.
Okay.
And then whenever it's heard, because you could file it and it could be continued and heard in 90 days or 120 days. But as long as you file it within 60 days,
Oh, the preliminary hearing?
then of the information agreement,
Okay.
then you have the right to take a writ. You're supposed to take the writ, I think it's 15 days from the date of the denial. And so there's a whole system involved in order to make sure that you can get some kind of interlocutory review if you want to. And a lot of times 995s do get taken up. And so you need to know it, because nobody ever told you that, all of a sudden you find out, oh shit, we didn't file it within 60 days, we're done. And so that's just like, the tentative rulings that can you argue. I mean, just something you gotta know,
Sure.
and it's written somewhere.
That's how you screw up and get in real trouble.
Yeah.
Like,
Well, I mean, if you don't get an interlocutory ruling on the 995, it's not like fatal. It doesn't mean it's still an issue for the case. It's just, it means on appeal. If you were right on the 995 and it should have been dismissed, you don't have a trial and you don't have the appeal. So it's nice if you get, it's very rare that you get rid of a case on the 995. And when you get one dismissed, usually the DA's office appeals that. And so that's why you see in some of your cases, you'll see in case books, it's about a 995 that's in the, the DCA or the appellate court, the Supreme Court. So that's all, that's all the mechanics of it. And then this is, the basics. So you learn who comes first and who comes next. And, trials are just the beginning of a case, although it seems like the end, but it's getting up to trial and then having a trial. And then there's all the stuff that comes afterwards, if it comes. So what else is there for you guys to go over?
As far as objections go during openings, I know like the main one is that there's argument, but what if they're trying to bring in character evidence and stuff like that?
Yeah,
Can you object?
What if I'm prepared to bring in? What if I'm prepared? So I'll say I'm prepared to bring in character in my direct because I have an exception for it, and I'm prepared for it. Should I tell them what catfishing is in an opening statement so they can because it's my time to really discuss what these things are.
What's an opening statement?
It's going to lay a roadmap for the entire
So what
case.
you believe the evidence will be.
Okay.
If you can in good faith, and by the way, in a real trial, you would have this 402 question done before you did your opening statement. You would know whether or not you can bring in character because you bring it up in a 402, but we're not going to have that here. You can say that if it is, I believe the facts will show that this is, man has horrible character because he screwed a lemming or whatever.
It's not. It's the whole story. It's part of the story.
That's fine. That's what you tell.
Okay.
And so you can object. I don't recommend you object in an opening statement unless it's really turning into an argument. But if it's just basically the facts will show this and this is what it will be and Mr. Jones will testify to that and Mr. Smith is going to say this, that's what an opening statement's supposed to be.
Okay.
There's a little argument involved sometimes in making a few inferences. You're not supposed to make inferences, you're supposed to say what the facts are going to be. But if you object that it's character evidence, there's not a well-taken objection because if he in good faith believes that you're going to get good character evidence, character or bad character evidence in, he can say that. Now, if he's saying this knowing that it's never going to come up, that is a fatal flaw.
Okay.
And it's an ethical violation, et cetera. But if you really believe that it's going to come in,
I do.
and normally you would know if it's going to come in at a real trial,
Okay, yeah.
Just say it.
No, I really didn't plan on objecting. Yeah, we were talking about it. I was like, I didn't plan on objecting, but we also weren't sure what the proper objections were during opening other than it's already mentioned.
Yeah, it's argument.
And in this, whatever the beyond the scope objection is.
The answer is in real life before to it.
Yeah, okay.
Yeah, but, I mean, if he's not way out of bounds, just let it go.
Yeah, no,
I mean, that's my preference. Some people object like hell. I didn't even like objecting in the closing argument. In fact, one of the last trials I had, the judge told me, well, you should have objected. And I said, I just don't have a practice of objecting. I told you as soon as they were finished with their argument, this is my objection, this is my concern, this is why I think we should have a mistrial. And he told me, you should have objected. I said, well, I don't think so. I don't think you have to object.
Oh,
The whole idea of objecting is so that the court can give it a curative instruction. If you can give a curative instruction or dismiss the case if it's that extreme, or mistry, not dismiss. And I was found to be less than persuasive. But I'm still the old school. I don't want to object. I mean, if it's really, really, really bad,
yeah.
But I mean, unless it's horrible, I just think you let people make their argument.
I just kind of wanted to know what the proper objections
I would hope
were.
that somebody would let you make the argument too, but that doesn't always happen.
And you gotta keep in mind, like, sometimes you don't know.
Yeah.
Right? I know it was frequently the case in my experience that a defense opening statement, I was hearing stuff for the first time.
Yeah.
Right? Because it wasn't stuff that was in reports. I'm like, okay, well, the only way this stuff ever comes in is if the defendant testifies.
Right.
And they would tell this big story. It sounds great. The defendant would never testify. And then when they started arguing, they would never mention it. And so in my rebuttal, I always used to stand up. Do you remember their opening statement? What a wonderful, wonderful story they told. Did you ever hear any evidence of that? Why do you think they told you that story? To put that thought in your mind, knowing that they couldn't back it up. And so you kind of dirty the other side without pointing at them and say, look at how dirty they are. Like, really? Really? They're gonna...
The response to this is, I told you what I thought the evidence was going to be, but when we saw this shitty case they presented, you said we don't have to do anything, and that's why my guy didn't come up there. You can't come up and not testify. By the way, there's a real thin edge there. If the prosecution or the defense comments on somebody not testifying, your defendant, that is, it creates a problem. The prosecution is called a Griffin error, and of course, if the defense says he didn't testify because of your crappy case, then they can say, well, yeah. But
if it was so crappy, they should have been up there.
So you do go back and forth on that kind of stuff. But it is true that some guys will tell the whole story. And literally, I've done this where I told the whole story, and at the end of the case, they go, shit, I'm not going to put my guy on and have him cross-examine, and that's all they could present. But it does look like you told the story. That's why I say you have to be in good faith. If you're telling this in good faith, but there's some people that are probably not in good faith, that are probably just doing it to do it.
And that's why my practice, because I don't want him to respond, I don't bring that up. In my opening argument, I don't bring it up that they didn't,
right,
produce evidence to support their story. I let them get up an argument, and maybe if I'm lucky, they'll even argue that same story.
That's even worse.
Right? And it's like, who testified to this?
Hmm.
Oh, counsel told you about that in his opening statement, which isn't evidence.
Yeah.
Right? And now he's telling it to his closing argument, which isn't evidence. When did you hear about any of this from the witnesses?
Now, would you object to the time, or just let him
let him go.
You can't object in the opening statement because if they're
Well, no, either an argument, you can say it's not in evidence. You can't
Well,
say these are in evidence.
you're talking about when if you in closing argument,
Correct.
argue stuff that wasn't presented.
Right.
No, because I
You
want
want
to
to hang
I want them to go. Keep going.
Yeah.
Keep telling that story.
But that's a strategy.
Right.
Yeah.
You could object.
Okay.
Yeah.
And you
For me, that's why I always
misstates the
did it that way.
or whatever.
But sometimes in an opening statement, you're hearing stuff for the first time, and your instinct is to object. There's no evidence of that. It's like, oh, well, maybe there is.
Probably especially on the prosecution side, because you guys can't talk to our clients. We're not
Right.
going to tell you jack. You
Right. But generally speaking, there's only one source of that information,
Right.
Yeah.
right? Because if you've got,
Well, if you don't have any of the reports and you're both up to speed, there's one place where it's coming from, if it's coming at all.
So, with regards to your openings, try to tell your story. If you want to walk down a character thing, okay, doesn't mean you're not going to object when he tries to bring it in.
Yeah.
To me, the exceptions are so obvious, because it doesn't matter. I'm not gonna.
So, I will have another question. Can you explain like what catfishing is during your opening statement?
That's
Provide
The evidence will show
Yeah.
Mr. Smith is going to be called and tell you about something called catfishing.
Yeah.
This is what he's going to tell you.
nothing to do with the charge itself.
Right, as long as a witness, as long as you have
You
a
have to
witness
make it
talk
come
about
from
it.
a witness. You can't just explain it.
Yeah, okay, that's what I was
Right.
wondering. We can't.
So it has to come from a witness who explains it.
Explain it right,
That
because
would be
these
hard.
kids will probably
Well, it could be.
know what it is, and they're gonna say, that's not what catfishing is, right? So.
Yeah, I asked.
So that's your Urban Dictionary.
Yeah, that's where I got the definitions.
I would not use the
I'm not
Urban
gonna use the
Dictionary.
I do have someone.
Your dictionary is cool. All right, you guys, I'm gonna go and I have to be the keeper of Miss Robertson, who's a speaker. And I just, I'm really looking forward to you guys doing this. I'll try and act as judicious as possible. And feel free to make objections. I mean, all I can do is say it's sustained or overruled, and the jury doesn't even know what it means.
And we want you to.
Yeah.
Right, we want, if you hear something that you believe is objectionable,
Make the objection.
do it. Right, we want you to get in the practice of doing it, because
When you get great experience, you may find a question objectionable, but it's technically objectionable and it doesn't change anything. You might choose not to object. But for right now, if you think that anything is objectionable, don't object to opening statements, but make it, make it, and we'll rule on it, and you can learn from it. And it helps you. I mean, the Bible of the courtroom is the evidence code, and the evidence code is where your objections come from, and we want you to transition from law school to, what really happens in the courtroom. So objections are good. And by the way, it tells you all the objections you can make.
Mhm.
So it should be pretty easy. Just got to figure out what objection should I make, and then do it.
Yeah.
All right, I'm gonna go and say hello to Jimmy Robertson. And if you change your mind, if anybody wants to go, I know you probably don't. Let me know, because I do have a couple of tickets. And otherwise, Anissa's coming, and her father, and John Evans, and a couple of people. And we'll just go down. Fortunately, it's early enough that we'll be home by 10 o'clock on Friday night. I have to have a nap in order to do this, by the way. But, all right, you guys, I'll be gone.
Hey, take it.
Can you send me a copy of what you have? If I'm gonna deliver this thing.
I have the page right now.
That's fine. I just
Now I
it's
want to
some
send
place to
it.
start,
Ask
Do you want to
you
read it or I want to
about
send it to you?
your input on something, because
Okay.
I'm at a
Yeah.
loss. I have like my opening and
Word
closing
is best.
done, and I'm gonna send them to
You
you
can
just so
word
you can
Okay.
Oh,
look at them,
yeah, I can.
All right. I'll send it.
but I'm a struggle.
Mhm.
And so I just wanna get your brain on something.
And what else do we guys got, right? And just as far as issues, any questions about, try to utilize what we've talked about. Okay, that's really what we're looking for, right? We gave you feedback during each exercise, right? So when you're giving an opening statement, try to keep it interesting and entertaining, and tell the story and get them engaged in what you're saying. Right, on direct, open the questions. Right, get your witnesses talking. On cross, leading questions, short, to the point. Like those are the types of things that we're looking for, is how well you've progressed and learned from the techniques that we've talked about. Right, when you get to your closing argument, argue. It's okay. That's the biggest thing I've seen young lawyers do, is they don't argue. They don't try to persuade. They stand up there and they repeat the evidence that they think is favorable to them, without attempting to persuade the listener that why that's right. It's okay to argue, and we encourage you guys to do that. So, I would say that, as you're going through this, keep those things in mind. And,
What about exhibits? How is that going to, I mean, we ask the witness, like, basically enough questions that we can, like, start to pull it out, and then we go get it marked? I mean, can we run through that again? How that's expected on the day of?
I would say for purposes of our trial, let's assume they're marked.
Okay, good.
Okay, let's assume they're marked, and
On page 57, it goes over how to introduce physical evidence.
57.
Yeah. And moving them into evidence, it says, 1, Your Honor, I asked that this item, describe it, be moved into evidence as people or defendant's exhibit number, whatever, and request that the court so admit it.
now,
You can object, and then the judge rules.
yeah, look, my practice, and there's a lot of books that tell you to do it that way. And most courts hate that.
Oh.
You know, that they don't want you introducing evidence one item at a time. You know, what most courts prefer you do, go through, lay your foundations, here's 1, here's 2, here's 3, you know, and my statement when I was done was, Your Honor, the people rest subject to a motion regarding exhibits. Okay, and then what we would do is we would then sit down outside the presence of the jury and say, defense, do you object to any of his exhibits? I object to 13, 14, and whatever. What do you say? And then you have that argument outside. They don't, most courts, I haven't found one that does, like you to go up, do you see this? Yes, what is this? This is a picture of my house. Your Honor, I'd like to admit people's exhibit number 1. Okay, do you see this? What is this?
Okay.
This is a picture of my driveway. Your Honor, I'd like to admit people's exhibit number 2.
So,
You know,
But you can't publish them, though, right? If you do it subject to a motion at the end, you can't show them to the jury.
absolutely.
Even,
And here's how you do it. Your Honor, could I approach? Yes. Could you take a look at this? I'm showing the witness, you know, it's been marked for identifications as people's 1. Yes. Do you recognize what that is? Yes. What is it? It hasn't been published yet. That's a picture of my house. And you recognize that? And is that a fair depiction of what your house looks like? Yes, it is. Your Honor, permission to publish. Simple as that. They're either going to say yes or no. If they say no, something's missing, right, in your foundation. If they say yes, you publish it.
but just because you publish it doesn't mean it's in.
Right, it doesn't mean
Okay.
it's in evidence, but
You can
you
always
publish
show
it. And the reality is, at that point, jury's seeing it. Do I care if it actually goes back with him? Maybe I do, maybe I don't. But most courts, especially if you've got a number of exhibits, don't want them admitted one at a time, and they really don't want arguments about exhibits taking place in front of the jury.
Mhm.
Okay? The textbooks tell you to do that because what happens, apparently some people forget to admit their exhibits. They don't admit them, they just mark them, and they use them, and they lay the foundation and everything, and we rest. Okay, other side, call your first witness. And then, oh, Your Honor, I didn't admit my exhibits. You know, can I reopen to admit my exhibits? Well, I'm going to object to reopening. You know, that's why they say to do that.
Okay.
So it keeps that problem from happening. As long as you know, and that's why I said, I always said the same thing. I rest subject to a motion regarding exhibits. It was never an issue. And if a court ever told me, and when you have those pre-trial meetings with the judge, you'll ask them, how do you want us admitting them one at a time, or you want us to deal with them outside the presence of the jury? Judge always says let's deal with them outside the presence of the jury. For our purposes here, and I think we're only going to have a handful of exhibits,
Right.
you're probably going to be fine
There's 4.
asking them to admit it right then.
Right.
You know, and that won't be a problem. But, you know, for our purposes here, make sure you're using the proper protocol. right? Don't approach a witness unless the court has given you permission to, you know, don't publish anything unless the court's giving you permission to publish. You know,
It's gonna be a rodeo.
just when it starts, people, you want to give your opening statement, you got permission to enter the well, right? Then enter the well. Oh, okay, you know, that's just protocol, right? Of course the judge is going to let you enter the well because that's where you give your opening statement from, but you still ask, okay?
Woefully unprepared.
I know, me too.
So, you know, but it's just, you know, like I said, those things just take time and practice, but that's what we're looking to see how, you know, how well you can do on that. Your foundation should be laid by a witness with the exhibit in front of them. Once you believe your foundation is sufficient, then, Your Honor, can I reapproach? Don't linger by your witness, but if it's going to be quick, you recognize this? Yeah, that's a text I sent to this one. Okay, you know, then right, maybe you stay up there and ask the questions while you're there with the witness. The way our courtroom is laid out, be careful because it's kind of a natural thing to turn your back to the jury to deal with the witness, the way this is laid out over here. Don't do that.
Like step back or something.
Or approach from the front, right? Approach from the front, leave yourself open to the jury. You're still going to have jurors right there, or
So the judge to your back and
or walk all the way to the side and open yourself up to the jury. You understand what I'm saying? Walk further up, and then that way you can still see the whole jury. Okay? What you don't want to do is be engaging with a witness with your back to the jury. Okay? So depending on the layout of the court, you're either going to go to the front or to the side. It won't matter for us. In real life, you're probably going to go to the side, because if you go to the front, you're blocking the court reporter, and they use a combination of hearing and watching, and you know, if they can't see the witness, they'll freak out. Even if they can hear the witness, you know, they'll want you to move. So don't block the court reporter either.
Keep this all in the back of your mind as you're trying to remember your case.
Yeah, I just need to get
That's leave the floor up just as.
I know, take like a map on
I'm
the
gonna wing the
floor.
motion at this point and just try to memorize my opening and closing. And I'm woefully unprepared. Like, I got this weekend, you know.
So,
Okay.
where do the briefs come into play in all this? Like, is that just during the pleading part? Like, when you're submitting pleadings for the judge?
Yeah. Yeah.
It's not,
You don't have to brief anything because
yeah,
your brief was to reply to your motion. There is no brief.
Can I submit,
Yeah, that's what I was
submit
thinking.
on my opposition? Is that acceptable?
Yeah. Well, the judge has kind of already given an indication of the next rule.
Yeah, I wonder how he's going to rule next Thursday.
But here's what you want to. And again, this is one of those things in real life. Your trial brief is going to be filed the day of trial, right? Because you probably, unless it's a death penalty case or a very serious case, you're not even going to know where you're assigned to until you're assigned there, right? You're going to be in the assignment calendar. They're going to say, okay, hey, this judge is open, go down there. And you're going to go down there, hey, clerk, here's my trial brief, you know? And most likely they will have not read it, right? They may have skimmed it. They're going to come out and they're going to say, I've considered everything. It's like, no, you didn't.
Right.
I always worked under the assumption
That they didn't read it.
that they didn't read it. Unless I'm in a calendar court, like I got a death penalty case and it's assigned to this court for all purposes, then I would assume they've read it.
I hate that, but it makes
You know.
sense. Yeah.
Yeah, okay, so yeah, it's just to get to whatever judge you get on
Right.
the same page.
So, you know, when you're dealing with these cases, most likely your trial brief is going to be handed to the judge as you get there to trial. And they may say, well, I got jurors waiting outside, so, yeah, you know, we're going to have to deal with this later. So then you're going to be picking a jury, not knowing what evidence is coming in or coming out. And, yeah, it could be a real pain in the butt. I think I shared with you guys the story. I had a case where I didn't know which witnesses I had. And
Yeah.
and the judge wouldn't let me get my opening on Monday. And it was like Friday at like 4:15 or something. And he was like, nope, give your opening. I have no idea what evidence I got. And so I waived it. Defense they objected. You can't waive his opening. It's like, yeah, you can. And of course, I was scared because they okay, call your first witness.
I don't know who my witness is.
He didn't go that far, but and then of course my case got really good over the weekend, and defense was kicking themselves. But
Well, it still helped the defense because you didn't get the chance to open.
right,
So I mean, he shouldn't be like upset. He'd be like,
right,
he still profited.
right.
Like look at it. It's glass half full, man.
Mm-hmm.
All right.
Okay. Here's what I would suggest you guys do. If you have use the time that you got tonight for you guys to communicate. Maybe we can, if you got anything, we can step out there and chat real quick. Try to get here early next Thursday to spend a little time. Maybe you want to talk to your expert and say, hey, I want to ask you these questions. Are you going to be okay with that? And if they say no, then scratch that. I'm not going to ask those questions. Remember, it's probably going to come in handy in this trial, being able to refresh their recollection, right? You may very well get witnesses up there that are saying, I don't remember, and it's because they
don't know it yet.
They don't know it yet, or
Yeah, that's what I was concerned about, to recollect an expert's memory, you have to still update.
yeah, and if they do, treat the expert like any other witness. If they say they don't remember, and you've got a piece of paper that has something on it, Your Honor, may I approach the witness? You show it to them, say you ask them to read it. The proper next question is, having read that, does that refresh your recollection? When they say yes, it has, then you ask the question. What a lot of attorneys do is they go, can I approach? They show them, like, okay, so what color was the car? And the person hasn't said it refreshed their recollection or not, right? There's that one step in between where you're supposed to ask, having read that, has that refreshed your recollection? Yes. So what color was the car you saw?
If you don't ask that, can you technically get like an asked and answered objection?
You can.
Because he didn't know.
Right.
You didn't make a reason why.
Depending on which judge you're in front of, they will smack you down.
Yeah.
A real stickler for a form like that is Judge Evans. Like Judge Evans will absolutely smack you down in front of the jury. And counsel, that's not the proper format. This witness hasn't, articulated whether their, memory has been refreshed or not. So, you're jumping the gun there.
Are we going to be voir diring these experts as well, like asking them about their education? Because I have a feeling they're not going to remember. And we're like, do we need to refresh your recollection on your education and your credentials? Or
yeah, I think that's part of the of just like laying your foundation, basically. Like you got to bring all that stuff in, right?
yeah, I know, but it's kids.
Yeah, that's
I feel like it cuts down your expert's testimony if you're like, you don't remember where you went to school or what your job is, huh?
And you want this jury to call you.
That's a ridiculous argument, though. I mean,
No, I know, and it's going to be the kids that are the jurors. anyways, but-
they go to
But that's a
Make it a
silly
real
thing.
fraud.
A lot of
Make it a
times
real
attorneys
fraud.
don't do that. When you call your expert witness, right? If you don't have a determination made pre-trial, which is rare. Most courts aren't going to unless it's a real questionable issue. Maybe they'll have you bring the experts in first. Like when I had my bloodhound case, our experts testified in a 4-day pretrial hearing before we decided whether that evidence was going to come in or not. Usually you'll lay your foundation for the expert in front of the jury. Okay? When you're done laying your foundation, you're supposed to have the court qualify your expert. Your Honor, I'd like Mr. Smith, qualified as an expert. And the judge will say yes or no. If they say yes, then you go on and you can ask them opinion questions and hypotheticals and all of that. If you haven't had them identified as an expert, you're not supposed to do that. But that's just one of those things that people skip. They lay their foundation and then they just treat them like an expert without ever actually having the court designate them an expert. So
It's all you, Victor.
I got that. Yeah.
Yeah.
I'll figure it out.
So yeah, when you're done laying your foundation, ask the court, Your Honor, may Mr. May was with it be qualified as an expert, and they'll either say yes or no, and then you respond accordingly. If they say no, something's missing in your foundation. That's why on your expert you should have a little checklist. What do I need to do to lay their foundation for an expert? Right? Education, training, experience, all that stuff. Specific knowledge on the subject matter.
When you question someone, are you just asking the questions from the table or from the little podium in the middle, or from where?
You're either wherever you want to do, but strictly standing.
Oh yeah, because I mean the movies let you be in the well, walk around. So I don't know where you're actually standing.
No, you're not going to walk around in the well unless you ask the court, and that's going to be. You're going to walk to the well to give the witness something or to pick something up and give it back. The only other time you're in the well is when you're addressing the jury.
Okay, so
Usually we have the podium right there in the middle.
So when you're direct crossing, you're going to the podium and direct crossing from there.
However you feel comfortable. When I'm directing a witness, I'm probably standing at the corner of the table closest to the jury.
Okay.
If I'm in trial, like a real trial, I would move the podium over there, and I would have my notes right there.
Okay.
But there's nothing that says you have to stand at the podium. You don't have to, and there's nothing that says the podium has to be in the center. Right? You can move the podium to wherever you need it. What I always want to do is I like having that contact with the jury.
I want you to stand behind me while I'm in between you and the jury. Making like weird, some weird stuff. Because you almost are kind of behind the prosecutor. Like that's my joke. But the truth behind it is that if the defense went to that podium, I'm in between him and his jury.
Sure.
Mm-hmm.
And you'll notice some people freak out. Like you walk behind them and they'll like cover up their notes and stuff. I like it because I just think it's a bad optic for the jury to see. Why are you hiding your notes, really? But some lawyers will do that. I have walked behind an attorney and they like closed their laptop. Okay.
With the judge or something.
Okay, all right. So don't feel obligated to stand behind it. If you're going to be comfortable moving, move. But just, have a sense of organization, walk your witness down. If they don't remember something, don't jump to the next step and then 5 minutes later say, oh, well, let's go back. Remember you didn't remember this? Can I show you this to refresh your? Hit it on the spot. Be prepared, and just demonstrate those skills.
Cool. I'm nervous, man.
You should be.
Well,
Because of you.
let me tell you, if I could, and I mean this in all sincerity, and this is not a knock on you guys, because you guys have all demonstrated good work throughout the semester. These kids may be very good.
Right.
Okay, I'm not
They're
kidding.
actors.
Yeah, they are. They may be very good. We had when I was coaching the Amistad kids here for the school. We scrimmaged Palm Desert, and Palm Desert kids are good. These are smart kids that are trying to get to college, and they take this very seriously, and they may Don't be surprised. Like if you're examining one of our witnesses, don't expect them to just roll over and give you what you want.
Right.
Like, they probably won't. I'm telling you, these kids, I have seen in years past, I've seen them be very good. So, that being said, we need to be prepared to let them be good.
Yeah.
Right?
Also kind of like the cross technique you said, well, it doesn't matter what their answer is, just keep asking the questions in the order you want.
Absolutely.
Right, your story. So I don't care what he's going to say or argue. Just like,
Absolutely.
yes, no.
Right, and we've talked about that, right? You ask a pointed question. If they don't answer it,
You react.
ask it again,
Mhm.
right? And if they don't answer it, right, maybe you ask it again with a little comment.
Mhm.
Like I said, I always just say, I understand you have a story you want to tell, because I want to put in the jury's mind that it's a story, but I'm asking you this, yes or no, and then they tell it.
So they start ranting, do you interrupt them?
Sure,
Yeah.
sure.
That's a polite way to do
I wouldn't interrupt them the first time.
Mhm.
After a
Can I
while,
bully the kid a little bit?
after a while, I would.
So you're an influencer, huh?
What's
You're not hot enough to be an influencer.
Right, and they may do that. You guys,
Their feelings a little bit.
right? You guys won't have to worry about that because you're not on the clock. They're on the clock, right? And if they can talk and talk and talk and talk and talk, you're losing all your cross-examination time without getting through what you want to get through.
So, how do you usually stop someone when they don't stop talking?
You just stop them.
You just stop
Yeah,
them?
you just stop them.
Stop.
Okay,
Shut up.
that's not my question. And if they keep talking, Your Honor, would you admonish this witness to answer my question? And Judge Dolan will. So
I'm gonna stop you there, That's what I would say.
yeah,
I'm gonna stop you there.
that's a good point. But my question was this,
Right.
and then re-ask it, and then
That's why I did it.
and maybe you just ask, them, right? Yeah, I know you're not supposed to ask open-ended question. Is there a reason why you won't answer this question? It's a pretty straightforward question. Yes, no, and then they go off. Okay, right. Then you look at the jury. So you're not going to answer that question. Well, I already did. Okay. And what was your answer? Right, because it won't have answered the question, and then maybe you just move on. At some point, you're demonstrating to the jury that for our purposes, they're not getting graded, right? And for our purposes, verdict is irrelevant. Okay. In real life, that's all that matters. in real life, you can do a fantastic job and lose, right?
That's
and
us.
you can do a crappy job and win. It just happens. But for here, you do a good job, we see it, right? And we don't really care how they do. That's for their coaches to do. Okay. He said too, last year when Palm Desert came over here to practice and scrimmage us, they had like 4 attorney coaches. I mean, they had a lot of attorney coaches. I'm like, man, how many coaches you got? One for each witness. So, one last time. What you got? Anything else? Now's the time because next week's showtime. Vincent, you got anything?
Nothing I want to say in front of that.
Okay.
No, I'll figure it out. I mean, I don't know, that's words put in.
Okay, we all did.
I'm just, yeah.
I was woefully unprepared as you are, so
I'm sure I'm more prepared than I think.
yeah.
Especially after working with that statement of facts and that motion. I can stand up right now and tell the story. You know what I mean? But I don't want to tell a story. I want to
I want to put seeds in them, and I want to use repetition, and I want to, you know, I want to use I want to do like, I want to be convincing about it without being argumentative.
Right.
Right.
And it can be done. You know, I'm telling you, there was a guy, he still works at the DA's office, Joshua Hill. I don't know if any of you have seen him. I absolutely loved that kid. And the very first time I ever saw him in trial was in a DUI. How glamorous is a DUI? Person was driving, he was under the influence, here's his FSTs, and I was blown away by his argument, his closing argument. It was just like, wow, good luck, defense attorney. What are you going to say to that? Hey, your guy's done right now. And he was probably done just on the facts. But I was so impressed because he did all of those things in a very basic DUI trial. And he turned out, now he does homicides and all kinds of stuff. He's just a fantastic lawyer. But he has that gift, right? He has that gift of argument, and he's just very, very impressive to watch.
But do you think that the best arguments don't appear to be arguments?
Yes.
Right.
Yes, and kind of like Dean Dolan says, when you can walk them to a point and let them come to the answer,
You win.
you win,
Right.
right? You want them to come to that answer. Sometimes you want to tell them what the answer is, right? Sometimes you want to frame their thought. But like I told you, like in a lot of homicides, you want to let them make a decision. You want to make them feel important. You want to make them feel like they've got a job to do. You don't want to tell them, like, we didn't really need you here. Just vote guilty and we're done, right? You want to let them think they're doing something. So sometimes I would pose a fake decision that they had to make just so they know that they had to make it. And that was never guilt or innocence, right? It was maybe a degree or something, you know, like he's guilty of murder, but you've got work to do here. You've got to decide is this first degree or second degree. Let me tell you how you get to first, right? And then I would just lay all it out. And it was a slam dunk first degree. But I want them to think they have they're doing something, they're buying in.
Makes them pay attention.
Right, absolutely. And then they would go in and they would argue for what they thought was right. And clearly what they thought was right was probably first degree because that was the overwhelming evidence. But they all came to that on their own. They went back there thinking this is what we got to decide. I never wanted to leave a jury walking back thinking, well, we got to decide, is this guy guilty or not guilty? I never wanted them having that discussion at all if I could prevent it. So what I wanted to always do is present them with something that they needed to work on, you know, and it wasn't guilt or innocence, it was some other decision, so they felt like they had something to do. Yeah, right, that was just a tactic, right? That was a tactic that I used, but didn't have to do that. I could just say he's guilty, and here's why he's guilty. But you know, we want you to use those types of tools if you can, you know. But don't make yourself awkward and hesitant because you're trying to do something instead of just being natural and confident. If you can tell your story, tell your story. And if you got the wheels thinking about, you know, what was the language I wanted to use, and I wanted to inject this theme into it, and you know, you're not telling the story the way you want to tell it. So, you know, don't lose the confidence angle, because just being comfortable and confident up there gets you a lot farther than trying to do these other things. I still remember I was successful at trial. That's why I got, you know, more and more serious cases assigned to me. My very first death penalty case, and I never wrote out a closing argument, but my very first death penalty case, I wrote out my argument. because I was like, oh, I don't want to say the wrong thing. I can't make certain arguments. I can make other arguments. I know I can talk about victim impact where before I could. So I was very, I wrote it out word for word. So I wanted to do all of those things that I already had been doing in my career without really trying, without having to put thought into it. And I felt awkward, right? Because I wasn't talking to them. I was following a script that I had never done before. And I caught myself thinking, well, look, I'm farther down. Then I skipped a paragraph. I skipped a concept. I skipped an idea. And, ultimately it was a successful argument, but I didn't feel good afterwards. Like, you know what? I got away from what I feel comfortable doing, and I'll never do that again. So, we want you guys to be comfortable in how it is that you're going to interact with witnesses and you're going to interact with the jury, more so than the content of any techniques. That will flow. The content will come. You'll hear another lawyer say something and be like, that was fantastic. I'm going to incorporate that into mine, but you've got to be able to stand and deliver. And if you can't do that, then you lose whatever power you have in your content. So that being said, if you don't have any more questions, I'm going to leave you two to talk. Me and Vincent will step right out there and we'll do our conversing out of your earshot. And then we'll remember, wear your nice clothes, which I'm kind of pissed about because next Thursday I do not have court, so I do not have to wear a suit, but I will for you guys.
I appreciate that. I'm sure they don't.
Yeah, so I will suit up even though I don't have to for work, for my real job. I had thought about it. I said, if I had really thought about this, I should have just had the Palm Desert attorney be your partner.
I already know the case.
But
I think Jeff McConaughey is your partner. You should though. You do less. You don't do anything. Like you're a law school. This is your
Figure it out.
Yeah, figure it out. All right. So we're gonna step out. You guys look at your stuff. Victor, I'm gonna leave you in charge of the sheet. Turn that in. Somebody didn't sign it.
So it wasn't here, so
Apparently not.
nobody saw him.
Don't be trying to listen.
Ready? I think that I can get ready. The thing is that I can't believe how much there is to do, opening, closing, directing Cameron.
And the rebuttal has to be done on the spot, right? You can't really write. How do you write a rebuttal? Like, I don't mind doing it on
The opening, the opening and closing kind of like rhyme each other.
No, it's not cool with that. But just the rebuttal is like,
Yeah.
I have to do it on the spot, right? So it's no big deal.
I mean, yeah.
I mean, I did this one on the spot last time we talked.
I think that the person doing the other person doing the reply can be very strong because you can sit there and you can listen to me and take actually just objectively listen, right?
Mhm.
Without having your own feelings about what I just said, what I didn't just say. Did they hear it? I guess because as a third person you'll
get tunnel vision. That's your own issue.
right. Things that I did say that. It's like, well, no, they didn't catch it. You know what I mean?
Mm-hmm.
I would.
But then the reply, I won't have the tunnel vision. I'll just listen to whatever.
Right. So listen to me and then listen to Vincent and fucking clear those issues, man. If there's anyone's vague, if he caught me in some way,
Yeah.
show good up his ass. Yeah, man.
Yeah, I mean, I was just writing out the questions for the directing and stuff. I was just like, the only thing I was worried about is with the extras, I'm like, well, you tell me what's going on. But
Right.
If I get an expert that's like, I don't know.
Well, the hard part in bringing, because you're basically bringing in all the evidence.
I have to link all the evidence to who I'm asking, then I have to tell them, is this your report or is this your?
Right, but where you start out is you gotta start out with setting up their credentials. Who are they?
Yeah.
What have they done? Like, you know, even like setting up a rapport with them, you know, you work over there, like, wow, it's a long drive. You know, who knows where she works at? I haven't read that stuff, but I don't know, man. I'm nervous as fuck.
It's just an hour. I'm just moving out that life.
Cool.
I'll just be nervous for like the first 10, 15 minutes and I'll get over it.
How are we doing bullying as a theme? Or not really?
Well, that's the whole thing about packet, how swatting is wrong, which is such a dumb thing for us
I don't
to do, but it
understand.
is the real thing.
I don't understand how it's bullying.
Well, it is though. Okay, we grew up on the internet where cyberbullying wasn't really a thing for us because we know how to turn off the computer.
To me, bullying is intentionally lowering somebody in their status.
That's exactly what's happening.
This guy just called the cops on him and got him like fucking whacked.
No, he bullied with the whole catfishing and constant picture posting and saying, "Oh, this is,"
Oh,
because he posted a bunch of defamatory pictures.
right.
You know, the bird taking.
That's bullying, definitely.
That's like,
Potentially seeking to lower someone's status.
so that's exactly what he
That's
was
exactly
doing.
what he did. You're right.
But then when they pushed too far, sort of retaliated, then this guy retaliated with the SWAT team.
Right.
Special weapons tactics. You can see the whole thing because it sounds scary.
Right.
Yeah, it's just. I don't know. That's I was like, the opening I sent you was kind of BS. I'm like, how do I make this guy sound terrible? So just trying to make this guy sound like a victim.
Just to make this clear, I have Cameron Holmes on direct.
Yeah, they got the text.
And Reagan Klein and Sam Golostian, right?
Yeah, because I was just going off the text they sent me.
So I got 2 crosses and 1 direct, and that's it, right? And open and close. That's my whole trial. Because I'm going to totally tunnel vision into what I need to do, and like let you just do.
Yeah, I was gonna do the
you know?
same thing that way. I can tunnel vision my stuff.
Right.
So I have Sawyer, then our linguist, and on our cop. And then on cross, I have their linguist and the cross of their friend. Cross the friend. Which friend am I crossing?
Marlowe.
Marlo, okay, crossing Marlo. Okay.
So yeah, he's so he's gonna say that Cameron probably did, right?
Mhm.
That so like, how you gonna cross him?
I'm gonna just not care what his answers are. Just.
Oh, I think you okay. Well, no, but
I feel like that's the easy way. Just ask questions that I don't know his answers, and I'll just say my story.
I understand that as